Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws Tube. In this edition, we look at the answers to questions in probate and estate administration. What is probate? Well, when there's a will, the probate is a process where the instructions of the will are carried out. The will is admitted to probate in New Jersey, many of the states, by an entity called the county surrogate. Now, let's see, what has to be done? Well, let's say first of all, you need to locate the original will. You need to get a original death certificate with a raised seal and take out your checkbook. Let's say most surrogates' office have a probate sheet, and the probate application should contain the following information. One, the applicant, that's the executor's residence. Now, if there is a will, that's called the person in charge is an executor. That's probate. If there is no will, the person then it's called an administration, and one of the family members has to come forward with the permission of the other family members to become the administrator. So we're also going to talk about probate where there's a will. So the probate information, in addition to the executor's name and location, has to set forth the name, address, and date of death of the person who died. Let's see, obviously from the death certificate. Name and address of spouse, children, and people who would take if there is no will. That's important. In addition, let's say if there's any minors who would take under the will, that has to be provided as well. So there's certain information that's required on that probate sheet. Rather than just showing up, we like to fill it out ahead of time. Let's see, and fax it to the surrogate's office. Also fax the will and death certificate. That way it takes less time. Once the surrogate sees all those papers, they will have the executor sign paperwork that sets forth that they will do the job. They pay the fee, and now this will can't be admitted to probate in New Jersey, for 10 days. You don't have to wait 10 days. They just can't be admitted to probate for them. Once the will is admitted to probate, the surrogate's office sends out paperwork to the executor saying, okay, you're in charge. What does the executor have to do? Well, they have an attorney. Either the executor or their attorney has to send out to all the beneficiaries what's called the notice of probate. And in addition, it has to set forth that the will was admitted to probate, who the executor is, where it was admitted to probate, and that a copy of the will will be furnished upon request. I find it's a better practice is just send out the will with it, so there's no questions. There's also a requirement under New Jersey court rules that that notice of probate be sent to anyone who would inherit if there was no will. The surrogate's office in many states does not handle disputes. That's handled by a superior court judge. What has to happen next? Well, as I mentioned, if there's no will, if there's a spouse, the spouse can become the administrator. No spouse, then the children can sign a renunciation agreement to have one child become the administrator. Unfortunately, if they can't agree, then there has to be a complaint order show cause before a superior court judge requesting someone be appointed as the administrator, and that becomes additional work. And where there's no will, typically a surety bond has to be purchased. So that's the kind of information that reasons why people should have wills. If the will is not formally executed, let's say, then the surrogate can admit it to probate, and there has to be a complaint and order show cause before a superior court judge to get a will admitted to probate. And if they can't find the original, there's a presumption that the original was destroyed. Inheritance taxes in New Jersey have to, the return has to be filed within 8 months. That's in tax paid within 8 months. Now in New Jersey, there's typically no inheritance tax if it's going to children or grandchildren, but the return still should be filed so that they can obtain tax waivers. Next are Unpaid inheritance tax is a lien upon property. Yes, because to sell property, let's say the executor administrator needs to obtain what's called a tax waiver from the New Jersey Inheritance Tax Bureau. And after that's obtained, then their attorney needs to file it with the county clerk. Otherwise, if it's going for sale, many title companies will not let the deal go through. Are there federal state taxes? Well, in 2012, federal state tax amount was $5 million. But in New Jersey, for example, it's only $675,000. There's an unlimited federal amount that someone can leave to a spouse. The surrogate's office will provide, upon the payment of a fee, what's called the surrogate certificates, and that's needed. We call them surrogate shorts. That's needed in order to have banks transfer assets from the bank account into an estate account. Let's see. Also, it proves that the surrogate that the executor has the power to do certain things. Let's see. What else is the executor required to do? Well, let's see. Make sure that the bills are paid. File all the returns. Let's say sell the assets. Distribute the property. There's more information on our website, njlaws.com, as to the duties of the executor. For other information, hire a law office. Kenneth Vercammen. His phone number is 732-572-0500. Thank you and good luck.